Good afternoon, everyone. It's great to be back with you here on the Tuesday webinar. I was thinking as I was collecting my thoughts this morning that we started this webinar just about 3.5 years ago to the day. And it's been a great pleasure of ours to present it. We're glad to be still able to do it. Lots happened in the last 3.5 years, and frankly, there's a lot still happening. And so let's hop into it here today and get started. First of all, I wanted to just remind everyone that we've got a fall labor and employment breakfast briefing series. And these are in-person presentations at all of the locations that are listed here on your slide. You can certainly go to our website, bsk.com/events to learn more and to sign up, or reach out to one of your favorite bond attorneys and they can facilitate that for you as well. But we're looking forward to presenting on this topic. This is one of the topics that we have repeatedly received in the feedback, so we appreciate your feedback. It does matter to us, and I think this will be an interesting and hopefully helpful breakfast briefing, so we encourage you all to attend. Let's take a quick look at today's agenda. We're going to go into these topics in a little bit greater depth today because we've got a little bit of extra time. And so we're going to start off with Rob Manfredo talking about captive audience meetings. We're going to turn it over to Nick Jacobson to talk about paid family leave, discrimination and retaliation issues. And then we'll finish with James Lauria on the Corporate Transparency Act and the New York City LLC Transparency Act. So without further ado, why don't we get started here, turning it over to Rob. Rob, this is an interesting development here. Thanks for taking us through it.
Absolutely, Pete, and thanks for having me today. For those of you that are unfamiliar with the phrase captive audience meetings, it's a phrase that we've often heard in labor relations. If you've ever had the unfortunate experience of going through a labor organizing campaign, you probably at least have some familiarity with this concept. And so for several months now, we've been hearing rumors that the legislature has been looking to pass a bill that would effectively outlaw or prohibit captive audience meetings on the state level here in New York. So let's hop into the actual statutory language, and we can talk about what that looks like in the statute and how it's going to impact businesses moving forward. So if we could look at the next slide, please. So this is actually an amendment to Section 201D of the New York labor law. This is a section that should sound somewhat familiar. It's the statute that has been amended recently a few years ago that allowed for the recreational use of marijuana. So this particular statute is kind of often referred to as the statute that allows for different types of recreational activities. And you'll see some of those on the screen. What it basically does, the 201D, is it prohibits employers from taking adverse employment action against employees for engaging in certain types of activity. And that would include, as you see on the screen, political activities that are conducted outside of work, the illegal use of consumable products, recreational activities, which now includes the recreational use of marijuana, and membership in a union. And many of these, with the exception of recreational use of marijuana, have been in that statute for a number of years. We are seeing now this additional amendment to the law, which was signed by the governor last week on the 6th, which will effectively prohibit captive audience meetings from taking place. So let's take a look at the next slide and we can kind of dive into the actual language of the statute. So what this statute does is it kind of breaks it down into two different types of prohibitions. So employers are now prohibited from taking any adverse action against an employee based on an individual's refusal to either attend an employer-sponsored meeting with the employer or its agent, representative, or designee. The primary purpose of that meeting being to communicate the employer's opinion concerning religious or political protection is an individual's refusal to listen to speech or view communications, the primary purpose of which is to communicate the employer's opinion concerning religious or political matters. So the devil's in the details with this as we look at what the definitions are of religious or political matters. So let's take a look at the next slide. Okay, so here's where we get into this whole idea of captive audience meetings. And just before I go through those two definitions, the essence of a captive audience meeting, as we understand it in labor relations, what we're typically talking about in that context is during a union organizing campaign, an employer may want an opportunity to express their opinions on unionization. And that often takes place in a setting where employees are assembled in a room and management will get up there and they'll talk about why they think that unionization is not necessary. Those meetings tend to be mandatory, which was where we are kind of deriving this idea of a captive audience. You're mandated to go and listen to those opinions, listen to that pitch by management for why they don't feel that a union is necessary. So now in the context of this statute, when we talk about what is prohibited and being prohibited from taking action against an employee for refusing to attend a meeting where there is a discussion about political matters, and we look at the definition of political matters, it relates to elections for political office, political parties, legislation, regulation, the decision to support any political party or political civic community, fraternal or labor organization. So getting kind of at the root of what we're talking about today, when we kind of put all those pieces together, it will essentially prohibit an employer from disciplining an employee if they refuse to sit through a meeting where the employer is expressing opinions about a labor organization or the employee's choice to join or support a labor organization. In addition to that, it does also cover religious matters relating to religious affiliation and practice and the decision to join or support any religious organization or association. Let's take a look at the next slide, Kathy. So there are some areas that are not prohibited by this statute, and we have them here on the screen, but basically I'll just run through them quickly. It does not prohibit an employer communicating information that the employer is required by law to communicate. It doesn't prohibit an employer talking about the necessary duties of performing an employee's job. If you're a higher education institution, there's an exception here. If the meeting is about a communication that relates to coursework, symposia, or any academic program at the institution, in addition to casual conversations, and it actually uses that phrase, casual conversations in the statute between employees or between an employee and an employer representative, provided the participation in the conversation is not required. So if we look at that in the labor relations context, right, that wouldn't necessarily prohibit a supervisor talking to employees about the supervisor's thoughts on unionization, as long as the employee is not required to sit there and listen to that communication or to engage with the supervisor with that communication. And then finally, it does not prohibit a requirement limited to the employer's managerial and supervisory employees. So big picture, let's take just a look at the next screen or the next slide, please. There's a couple things that we have to think about right now. One is that this law does take effect immediately. So, updating policies is going to be important, making sure that you're educating your supervisors on these new prohibitions. If you're actively part of a union organizing campaign right now, I would confer with your outside legal counsel and certainly steer clear of engaging any captive audience meetings. And then finally, there is a requirement that you have to post a notice about the rights that employees have under this statute so that they're aware of what their rights are under the amended 201D. I would just drop a quick note here to mention that this is not something that is completely new. The concept of captive audience meetings and some of the I guess feelings from the legislature and from the NLRB in particular about these types of meetings taking place is not a concept that's new. There has been a push at the NLRB, the National Labor Relations Board, with their general counsel to actually take steps at a federal level to also prohibit these types of meetings. So it's somewhat of a non-issue here now in New York State because we have this particular statute that will prohibit it. But this is really a very narrow, very kind of discrete area when we talk about it in a labor relations context. Clearly, this does also apply across the board to some other types of communications, as you saw with the definitions that are provided for in the statute. But giving it some thought, I think anytime you're going to be meeting with employees for some type of a required meeting, you've got to kind of keep this into context. Pete, I'll kick it back to you if you have any comments on the NLRB front of it, or we can move on to the next speaker.
Yeah, Rob, maybe just a couple of thoughts here that we can, kick around before we move on to Nick. First of all, this is an interesting issue, as you say, because it's really regulated, at least initially, perhaps primarily, some might even say exclusively by federal law.
Right.
At least with respect to private employers, the National Labor Relations Act. So there is a question here about possible preemption. Well, I guess it remains to be seen whether somebody will, commence a suit. I believe that there are statutes in other states that are similar, and at least one lawsuit has already been commenced to try and challenge this as being preempted by federal law, which would mean federal law governs and the state can't get into that area.
Right.
But as you say, maybe it's all moot. I mean, if the NLRB is moving toward pronouncing that captive audience speeches are inherently coercive and therefore unlawful under federal law, then we could end up in the same spot.
Yeah, I have a feeling that's where we'll end up. I think, looking at a number of the decisions that have come out of the board, even over the last several months, I'm not going to be surprised if we see a decision to that effect over the next 6 months or so.
And, the other thought I guess I had for your comment is, taking a step back, the point of this from the employer's perspective is to convey information that can be helpful and useful to the employees when they make this decision about whether or not they prefer to be represented by a union or not. And that's typically occurs in the context of, a union election that the NLRB would conduct, and trying to make sure that employees have complete information prior to that. There is some question about whether forcing people to come to a meeting is going to be productive. And I think a lot of employers have already gravitated away from the captive part of the thing to say, look, we're going to have an informational meeting and, you're welcome to come. And, at that meeting, we're going to share some information with you. So query whether this is the best strategy for achieving the goal of communicating. And so some employers may not be, that adversely affected by this if they elect to go the other route.
Yeah, I mean, the real crux of the whole statute is that it's the compulsory nature of it, right? That you have to go to the meeting. I think, and I agree with you, I think having been involved in a number of organizing campaigns in the last couple of years, I think many employers get away from that, the compulsory nature of those anyway. They don't want employees feeling like they have to sit there and listen to management. So I think the voluntary nature of it is certainly probably the more prevailing practice right now amongst employers. So it kind of sidesteps the whole issue from this statutory perspective. I do see we have a couple of questions in the chat. Many of them are asking about a copy of the notice to post. I haven't seen one yet. This was just the law was just passed last week, so I haven't seen anything specifically from the state. But certainly we'll keep an eye on it, and we can maybe refresh this topic if we do see something that comes out in the near future. Otherwise, I'm sure there are ways we can kind of put together a sample notice that may touch on these prohibitions for purposes of immediate compliance. I'm just looking at some of the other questions here.
While you do that, Rob, I'll give you a second to think here. One of the things that you did flag this, but the casual conversations part of the statute also, I think, has caught a lot of people's attention, because I'm not exactly sure how that's going to be construed, because I think the the notion of people who are free to leave the conversation probably is captured by the captive, and maybe that's what they mean by casual. But if information is conveyed in the course of that discussion, presumably that's permissible under federal law, And if it's not a requirement that the employees stay and listen, presumably it'll pass muster under this statute, but I guess we'll have to wait and see on that.
Yeah, for sure. Um, I think the only other question I'm seeing here, somebody asked, does this apply only during union organizing or at all times? And it would be at all times. It's not specific to union organizing, although that obviously would be one of the more obvious examples of when this could come into play. But it does apply, at any given point in time. And as Pete mentioned, there is this other issue with regard to preemption under the National Labor Relations Act. So we'll have to see how that plays out as well.
Okay, well, interesting stuff. And I think increasingly important, even to non-union employers. There's an awful lot going on at the NLRB, and we're seeing more labor activity, locally, regionally, nationally. And so, these are important issues, whether you're a unionized employer or not. It's very active these days on the federal labor front. Thank you, Rob. And let's move on now. We'll bring Nick in to talk a little bit about paid family leave for discrimination and retaliation claims.
Thanks, Pete. So this is something that our firm is seeing more of, and it can be a bit confusing and challenging to respond to. So we just wanted to highlight this so all of you know what to expect if you happen to get one of these claims in the mail. So Kathy, next slide, please. So New York paid family leave was enacted in 2016 to provide paid leave for employees to bond with newly born, adopted, or fostered children, to help care for covered family members with serious health conditions, or to assist covered family members who are being deployed to military service. Under the law, most private sector employees are eligible for leave, and covered employees can receive up to 67% of their weekly wage, with a maximum of $1,131 currently, going up another $20 next year in 2024. Next slide, please. So under the law, employees are entitled to reinstatement after they use paid family leave. And sections 203A and 203B of the New York Workers' Compensation Law prohibit employers from retaliating against employees for using paid family leave. Employees who are denied reinstatement or are otherwise retaliated against can bring a claim against their employer pursuant to New York Workers' Compensation Law 120. And New York Workers' Compensation Law 120 is the statute that prohibits employers from retaliating against or firing employees who make a workers' compensation claim. So now that same logic applies to employees who use or file a claim for paid family leave. These types of claims are also handled administratively through the New York State Workers' Compensation Board. Next slide, please. So when an employer receives notice of a paid family leave retaliation claim, they're going to receive workers' compensation form PFLDC 119. And the reason that I use the specific form here is if you go through this process, the Workers' Compensation Board is constantly referring to specific forms, saying you need to file a specific form or respond to a specific form. So that's the first form that you're going to see come in the mail, and it's a reinstatement request. And with that request, the employee can seek reinstatement to a job after termination, or even if they weren't terminated, they can seek a return to the same hours that they worked before taking leave, a return to the same job duties that they performed before taking leave, or reinstatement of the same benefits that they enjoyed before taking leave. The employer has 30 days to respond to the initial reinstatement request, and there's instructions in that reinstatement request as to where the employer's response needs to be directed. Next slide, please. If the employer does not respond to the reinstatement request or the employee isn't satisfied with the employer's response, they can escalate it to the next step by filing a paid family leave retaliation complaint, which is form PFLDC 120. The employee has 2 years to file a retaliation complaint, either running from the date that the employer responds, or if the employer doesn't respond, from 30 days after the initial reinstatement request is filed. If the employee files a complaint, the employer will receive a notice from the Workers' Compensation Board, another form, PFLDC 129, and then has 30 days to file a response on form PFLDC 130. Next slide, please. So claims proceed virtually before an administrative law judge, essentially through the same process that the Workers' Compensation Board utilizes to resolve workers' compensation retaliation claims. The notice of paid family leave hearing notices a preliminary hearing to discuss potential resolution, scheduling of the administrative trial, and also to discuss potential witnesses and exhibits that are going to be needed for the trial. That is not clear from the notice that the employer receives in the mail. In our experience, employers get the notice and they think that the actual trial might be starting on the date that's noticed. That is not the case. You're going to have a preliminary hearing to discuss all those housekeeping matters. Also, in our experience, communications with the Workers' Compensation Board and submissions are handled via email. Next slide, please. Okay, so some things to note. This process is very similar to the process that employers might be familiar with working through the Division of Human Rights to respond to discrimination and retaliation complaints filed there. One major difference is there's no investigatory phase. If you're before the New York State Division of Human Rights, an investigator will be assigned. There'll be a preliminary conference where the investigator will ask the witness questions, and then the Division of Human Rights will issue a determination as to whether or not there's probable cause to support the complaint. None of that occurs in this arena where you're dealing with a paid family leave retaliation complaint. The process moves forward a lot faster and without that investigatory phase. One significant difference is under the regulations accompanying the paid family leave law, they provide that if the employee was ineligible to receive family leave benefits at the time they submitted a claim, that may serve as a basis to disallow a discrimination or retaliation claim. So it's a little bit different than when we're dealing with a normal retaliation claim, and the standard is whether the employee had good faith to believe they were engaging in protected activity. Here, if the employee isn't eligible for leave, that may be a defense to a retaliation complaint. Another thing for employers to note, when you get the notice of hearing, it's going to talk a lot about registering for the e-case portal. In our experience, we've done that, but I have not actually had to use the e-case portal for anything. It appears to me that it's more of a portal for the submission of medical records and things for a traditional workers' compensation case. All of the submissions and communications that I've had during the process have been directly with the Workers' Compensation Board, administrative law judge via email. So don't stress too much when you get that notice if you're having trouble registering for the e-case portal, because it was a very difficult process in our experience. The last thing I'm going to note for everyone is all appearances are virtual. Even if the notice of hearing that you get specifically lists the location as a workers' compensation office, call before showing up. In my experience, if you show up, you'll meet with a very confused person at the desk and you'll be appearing by Zoom on your phone from their lobby. So just note that, don't plan on showing up in person. If you're going to be proceeding on your own, it's virtual appearances. And Kathy, you can click the last little pop up here. Don't be like me. Don't get fooled by that notice and show up in person. Um, and again, we're here. If you do receive one of these things, we haven't seen a lot of these PFL retaliation complaints coming through, but we're starting to see more of them. We're here. We're happy to help because it is certainly a confusing process, even to attempt to respond to what you get from workers' compensation in the mail. Um, Okay, and I see one question in the chat. Can we change a person's duties due to the needs of the program while they're on PFL as long as their pay and hours are the same? So this is a kind of complicated question. I'll try to address it somewhat briefly. So under the law, employees are entitled to reinstatement to the same or a comparable position. So it is possible that the needs of the employer can change slightly and that they could be returned to a position with comparable job duties. It's also possible that the needs would change and that an employee's assignment might have to be altered for reasons completely unrelated to them using leave. So under specific instances, yes, the duties can be changed, but definitely something that you want to run by an attorney first, just to avoid being on the receiving end of one of these PFL retaliation claims.
Hey, Nick, thank you. Two
Sure.
quick points before we let you go here. First of all, I think your points about the logistics of this process are very well taken. It's kind of, I wouldn't even say kind of, I think it's very confusing. The notices are not as clear as they might be. What the next step is often not clear. Usually, once the judge gets involved, the judge puts it in an order, and then it becomes much more clear. But the preliminary steps and how you appear and how you submit documents and things like that are a little bit confusing, at least in my view. So your points there are well taken, and I like your advice to don't stress, but I mean probably it makes sense to reach out to somebody to get a little bit of help there, because I would not want you to impair your rights at the early stage by missing deadlines, failing to appear, things of that nature, and it's not intuitive.
Correct, 100%. And with the e-case registration, the ALJ did tell me that we did not need to register for that. We did, and I wouldn't tell anyone not to register for it. But at least, if you're an employer and you're staring down that preliminary hearing and you haven't registered, I don't think it's going to be a disaster for you. Because again, that e-case portal was not utilized at all during the process. And one last thing to say, I would say that, as I mentioned earlier, it's similar to the Division of Human Rights process, but much more abbreviated. In our case, I believe the most recent one I was involved with, we got the notice of preliminary hearing in March, and we were set for our first trial date in June. So much quicker than the Division of Human Rights process.
The other thing I wanted to touch on briefly, and it's inherent in the title of your topic, but discrimination or retaliation claims, and in particular the retaliation piece, and the question that you answered by our listener or viewer about changing job duties, and all actions subsequent to the filing of a claim here need to be analyzed through the lens of a potential retaliation claim. And I don't think that means that people can't act and follow their usual processes, usual discipline, the usual performance, the work rules, things like that. But I do think we need to be careful to make sure that we can demonstrate that those are the usual processes, and that that nothing has changed as a result of the filing of a claim. I'm always moved by, years ago, we did some jury surveying and worked with mock jurors, and some of the things that lawyers do to make sure you're on top of what what people may be thinking in the jury pool. And there was a strong majority of people who started with the proposition that an employer is likely to retaliate after a complaint has been filed. At first, I found that unbelievable, and then I was just merely troubled by it. But the notion, I think, is this: that people are tapping into this idea of human nature, that if you're accused of something, you might be inclined to retaliate. So being able to defend that with pre-existing practices and policies and past practice and things like that, and frankly, good, reasonable explanations is incredibly helpful. So I think we probably want to emphasize that too as we close out this particular piece, Nick.
Absolutely. Yeah.
Okay, well, great. Thank you for that. There's a lot of process in there, but it's important to know. Okay, so we're going to move on now to James, and James is in our Melville office. He's a corporate lawyer, and that we're thrilled to have the folks in Melville who joined us. It seems like just a little while ago, but they've been here for quite some time now. So James, you've got some thoughts here on the Corporate Transparency Act and the New York City LLC Transparency Act, firmly in the realm of corporate compliance. Take us away.
Hi, everyone. Yeah, I'm a corporate associate. I work in Melville, business organizations, business formations. This Transparency Act and the corresponding New York law, New York bill that hasn't passed into law will be very relevant to, I imagine, most of our clients and small businesses across the state and elsewhere. And just getting everyone up to speed next year when everything starts taking effect. So we can go to the first slide here. Okay, so we'll start with the Federal Act because the regulations there apply to the New York Act. They're pretty similar in what sort of things clients are going to have to report. And so covering the Federal Act, which first of all is already a law and already has a plan in place for when it'll take effect, makes more sense. So passed in 2021, the aim of this law is to combat money fraud, financial terrorism, and things of that nature. And the government's creating a database for small businesses to report their beneficial owners, as well as just general information about entities they formed both in the past and going forward. So this is going to apply retroactively to clients that have existing entities prior to the law taking effect in 2024. The good thing being that we won't have to get all our ducks in a row right away for entities that were formed 20 years ago. You're going to have a year for existing entities to make sure everything's up to speed. But entities formed after the law takes effect in 2024 will only have 30 days to file the information we'll talk about soon. The database is going to be formed by the Federal Crimes Enforcement Network, and each entity that files the report with this network is going to get a FinCEN number. This number will be used in the database, which I don't believe has been created yet, but it's going to be all online where you can do the reports, where you can go and check the information that's been reported and update it in case anything is wrong on your reporting company and any intermediaries below that. So there will be some exemptions for companies that don't have to report this information to the federal government. However, for our purposes and the nature of the clients that both Bond has and what I imagine most people in our presentation here, they won't really apply. It's for larger SEC reporting companies, nonprofits, churches, security brokers, things along that nature. So the aim of this law is actually targeted towards transparency with smaller businesses, specifically LLCs, I would imagine. The criminal and civil penalties do exist for this, and there's a wide range of what looks to be applicable for violations. But mostly what you have to keep in mind is you're going to be reporting certain information, and if it's incorrect, you're going to be fined if you don't update it in time. And so it's important looking forward into 2024 for clients to review the sort of information they're going to have to provide and making sure things are accurate as soon as possible to avoid running the risk of violations and fines. We can continue. So the main focus of the Transparency Act is reporting benefit. Well, excuse me. First, we should start in terms of who has to report. There's going to be an applicant for every company. They have to submit information about the entity itself as well as information about the applicant. So that kind of information is going to be the entity's address, the entity's formal name, and some information about the applicant. The more detailed part and the more potentially problematic part is the information that's going to be required to be reported for beneficial owners of these entities. Beneficial owners can be either management, and that's a broad definition here of substantial control. I have a list here of some things that senior officers, people with authority over board members, people with important decision-making power, which is obviously a broad term, and people who have control over the intermediaries who are the owners of the companies. Those would be the management kind of people who would have to be reported under this act. And then we'll also need report information on beneficial owners, which include 25% or more equity owners in the company. You can't dodge these requirements. If an entity is owned by another entity, it's going to require you to report down the chain and report the ownership and management of those intermediate entities as well. So that's not a way to sort of avoid the privacy concerns with these kind of reporting. There should be a sample form provided closer to when this law takes place about what's going to be needed in these reports. It's not that complicated for individuals. It's mostly going to be legal name, date of birth, your address or a business address for some individuals, and then some kind of identification number. Usually an image of a passport or a state ID like a driver's license should be sufficient. And this information is going to go into the database and will not be publicly available unless in particular circumstances where the government would need to make it available. I imagine that would be in the case of some kind of investigation. So less concern there with the privacy issue. But when we get to the New York Act, the potential New York law, that becomes a bigger issue because some of the information there will be public. Well, let me just make sure I don't miss anything on this part. No, we can continue. So the New York LLC Act is sort of a corollary to the Corporate Transparency Act. It just passed recently in June from the Assembly, and Governor Hochul hasn't passed it into law yet. The main concerns here, the main differences being that the database will be publicly available for certain information, such as the entity's name, the entity's address, and the names of the beneficial ownership. But the identifying information, such as the driver's license information and the address of the individual beneficial owner, should not be publicly available to New York viewers. So that's an important caveat. The other main difference being that the New York law will only apply to LLCs doing business in New York, meaning entities formed in New York, and foreign entities are out-of-state entities who are doing business in New York. The law, well, actually, while we're on the subject of when it will become effective, the Corporate Transparency Act, of course, has a set guideline of 30 days for the new entities and 1 year for the existing entities. The New York law will take effect 1 year after it becomes law. So that's something to keep in mind going forward once we see it get signed. An important question to be asked when you're considering the New York law and the implications there is what it means to be doing business in New York. Doing business is a sort of a nebulous legal term that I've had to do a lot of research for in my few years being an attorney. It's generally pretty applicable to even if you own real estate in the state or you're doing any amount of substantial contact outside of one transaction, you're probably going to be subject to this law. So it's going to cover a lot of different entities, even for clients who have entities that are formed in other states and are doing some transactions in New York. Next slide, please. One thing I wanted to note as well is it seems to be that the filing you're going to make for the Corporate Transparency Act will apply for what you have to do for the New York LLC Transparency Act. So you're not going to have to make separate reporting documents for each to comply with each statute. So that'll be one nice thing that the state's not looking for additional information. And once we see what the federal forms look like in terms of supplying information on beneficial owners, that sort of information should be sufficient to comply with the New York statute. So I had a client recently ask some important questions that I think will apply to a lot of people here in terms of thinking about what to do as this law comes into effect next year for the corporate, for the federal purposes, and of course the New York whenever that takes place after. It's going to apply retroactively, so there's going to be an effort made by attorneys and their clients to have to figure out what entities have been formed over the year. I think a lot of the legwork here is going to be, okay, well, what entities are considered reporting companies for the purpose of these laws? And I don't think I touched on this earlier, but it basically applies to any entity that has to be registered in a state. So for our purposes, primarily corporations and LLCs, certain partnerships won't have to be registered and therefore shouldn't be subject to these transparency requirements. But going through and making sure that you have information on all these entities is going to be an important part to making sure everyone's complying with things here. We already talked about the retroactive application of these laws and the exceptions to public disclosure. A lot of clients may have individuals who are owners of these entities either directly or down the chain of intermediaries that aren't going to want their information to be available to the public database that New York seems to be requiring. Even if it's just the basic information like name and the address of the entity. Unfortunately, it looks like the requirements for New York are going to be pretty stringent, meeting an exception to requiring public disclosure. You're going to have a very material reason to not have to submit that kind of information. I imagine that would be some kind of along the lines of like witness protection or things like that, where that information could be harmful. So that does not look to be a workaround for some individuals. The other issue that this one particular client has is the investment in a real estate entity in New York. You know, if you own property out in the Hamptons or in the city and you have an entity that's just formed to own that property and operate it, is that considered doing business? And the New York laws on what qualifications to do business are pretty broad. And in fact, one of the stated goals of this New York Transparency Act is actually to finally get on the government for finally getting on top of figuring out who's owning these entities that own the real estate. So it doesn't look like entities formed for the purpose of owning real estate are going to be able to dodge the requirements of these laws. And penalties I've seen for New York are just civil and fines, but the federal statute, the Federal Corporate Transparency Act, does include up to $10,000 in criminal fines and potential jail time. I'm not 100% sure right now on to what extent that could be applied. I think mostly what this is going to look like is fines for not having your information up to date, and then making sure it becomes up to date. So I'd like now to go to the Q&A. Let me pull this up here. Does this apply to partnerships? I think that's going to depend on if the partnership is registered in the state or not. So some general partnerships would not be subject to these Transparency Acts. The not-for-profit exception is something I would have to look into more. But there are some exceptions for churches. I know that off the top of my head. And this is mostly going to be applying to small businesses. The next question I see, that's the family leave question. Apologies for that. Not subject to freedom of information laws. This would be a separate governing body and a separate agency regulating this kind of information. So all in all, I think this new legislation shouldn't be too hard to comply with once everyone gets the entities that they need to file in order. It may end up being more of a headache than it looks like off the front, but hopefully not too onerous on some clients and the information they have to provide, but something to keep in mind heading into 2024 and making sure that you and your attorneys have a correct plan to make sure we're in compliance with this. I don't believe there's any more questions, so that's the end of my presentation. Thank you.
Thank you, James. Very helpful. We'll keep an eye on that, and we'll update as needed as updates become available. Okay, thanks. Well, I think we hit the questions, but if you have any questions subsequent to this, here are your experts. Of course, you can always contact your contact here at Bond. But for these particular questions, you've got the contact information here. We want to thank everybody for being with us today. Hope you have a safe week, and we'll see you back here next Tuesday.